All right, let's jump straight into this explainer and really peel back the curtain on the administrative machinery behind the child support system. We're going to look at the legal architecture, the federal codes, and those hidden incentive structures that make this whole massive thing run behind the scenes.
Now, you might be wondering, who actually benefits from child support? We usually just assume this system exists entirely for the child. I mean, it's right there in the name, right? Child support. We picture this legal structure that's meticulously designed just to ensure the well-being of the next generation. But as we're about to see, the legal reality we're going to uncover might totally shatter those preconceptions.
Listen to this absolute bombshell summary of a Supreme Court ruling. It explicitly says child support was never intended to benefit the child or the custodial parent, but rather it was intended to benefit the state. That completely sets the stage for understanding the system's true purpose. When you actually dig into the case law, a wildly different picture emerges about who is really benefiting from the billions of dollars flowing through this system every single year.
So here's our agenda for today. First, the child support machine. Second, the multi-million-dollar incentive. Third, blessing versus freestone explained. Fourth, a systemic conflict of interest. And finally, navigating the legal reality.
Starting off with Section 1, the child support machine, and understanding Title 4D.
Okay, so what's incredibly fascinating about Title 4D is that this system actually originated largely to pay back state treasuries for welfare and cash aid benefits. When we talk about child support in a legal sense, we're usually talking about Title 4D. Created back in 1975 under the Social Security Act, this federal framework basically acts as a massive collection agency, making sure the government gets repaid for assistance grants like Medicaid and food stamps. Which brings us to Section 2, the multi-million-dollar incentive, covering federal funding and state metrics.
Get this, $735 million. According to Federal Code 42 U.S.C. 658A, states are allocated this massive pool of performance incentives for fiscal year 2025 alone. Yes, literally $735 million. The federal government actually pays states hundreds of millions of dollars in extra incentive money based entirely on how aggressively and effectively they handle their child support enforcement cases.
To actually get their hands on that money, states are graded on 5 specific metrics. They've got to identify legal fathers, create binding support orders, gather owed monthly payments, collect past due back pay, and maximize the return on state spending. But here is the absolute kicker. That $735 million is a capped national pool, so a state's share is their score divided by every other state's score combined. This means enforcement moves incredibly fast, because one state's financial win is quite literally another state's loss from that national money pool. Moving on to Section 3. Blessing versus freestone explained, looking at the Supreme Court precedent.
To really grasp the legal significance of these incentives, we have to talk about this pivotal turning point. It happened when Arizona Mothers on Welfare actually sued the state agency. See, the state was aggressively collecting child support from fathers, but keeping the money to recoup its own welfare funds instead of passing it on to the mothers. This legal challenge forced the Supreme Court to explicitly define who the system is actually meant to serve.
And the court's ruling? Well, they found the system was fundamentally designed to benefit the state treasury, not to protect individual custodial parents or children. The court explicitly stated that the Title 4D program does not create individual rights for parents. It merely acts as an administrative grant program meant to reimburse the government. Pretty eye-opening, right? Let's dive into Section 4, a systemic conflict of interest, examining speed versus due process.
Notice the incredibly sharp contrast here between these courts. On one hand, you have traditional circuit courts. They're built for due process, they allow full discovery, and they focus on time sharing and custody. Basically, they're built to protect constitutional rights. On the other hand, you have administrative Title 4D courts. These are built for rapid, metric-driven processing. They use quasi-judicial hearing officers to establish orders quickly and hit those state collection metrics. They don't typically handle custody at all. They literally just focus on the money.
Now, impartial observers point out that this structure poses some massive issues. For instance, allocating $30 million from the federal budget specifically to train the very judges and attorneys deciding these cases, critics argue that creates an undeniable conflict of interest, especially when the state is the one ultimately collecting the money. Plus, because these are administrative hearings, they often operate on a prima facie presumption of guilt. That means if you don't show up or actively challenge their paperwork, they just assume it's entirely true and rule against you by default, just to keep those metrics moving. Many argue this severely undermines a person's 14th Amendment right to a fair trial.
Finally, Section 5, navigating the legal reality, looking at default judgments and circuit courts. So, how does a default judgment actually happen? Well, it's a trap that snaps shut incredibly fast. First, a notice is sent in the mail. If you don't respond and object in writing within 20 days, the state legally presumes your consent. Just like that, a permanent default judgment is issued against you based on whatever financial numbers they've calculated, without you ever even stepping foot in a courtroom. No way, right? But it happens all the time.
You also absolutely have to understand the Bradley Amendment. This is a strict federal law, meaning that every missed child support payment becomes a permanent, unerasable judgment the exact day it's due. Even if your child actually moves in with you, retroactive back pay cannot be erased by a judge. You can't just stop paying because the living situation changed. You have to formally petition a court to modify the order moving forward, because legally they just cannot wipe out that past debt.
Given all this, legal professionals emphasize a few crucial realities to remember. First, immediately object to any administrative processes in writing within that 20-day window. Why? To demand the case be moved out of the administrative system and into a standard circuit court, where standard rules of discovery apply and you can demand actual financial transparency. Also, you absolutely must prioritize establishing joint physical custody on paper. Actual physical custody doesn't just automatically erase an existing order, and standard financial discovery motions often completely fail in administrative courts. If you don't have custody on paper, they might consider the other parent's income irrelevant, leaving you footing the whole bill regardless of the real-world situation.
So I want to leave you with this final thought to really chew on. How do we balance funding vital state programs with protecting an individual's constitutional right to a fair and impartial trial? When hundreds of millions of dollars in federal incentives are on the line, the pressure to establish these orders quickly is absolutely immense. Understanding the difference between a system built for administrative speed and one built for actual justice is the very first step in protecting your rights. Thanks for joining me for this explainer, and definitely keep asking the hard questions.